Hello, we're here at Litigation Fundamentals with Henry Quillian and Taylor English Duma in Atlanta. And we have another very informative class today regarding the impact of bankruptcy on litigation. As we've discussed, for those out there in the world, we are not here to provide legal advice per se, but definitely to give you topics to go investigate when you are dealing with litigation yourself. And of course, we highly recommend that you engage an attorney to actually learn the law that's and being involved. And also, in this respect, you probably ought to get a lawyer who does a lot of bankruptcy law, because it's very technical. But there are many things that can happen in litigation that bankruptcy laws can royally mess up for you. So we encourage you to know these things so that you don't fall into these traps. Today we have John Rezac for his second session on bankruptcy law. We are drilling down a little bit. He gave sort of the overviews in our last video. And he is a bankruptcy specialist here at Taylor English Duma in Atlanta. He's worked in creditors' rights and on both sides of bankruptcy cases for 20 plus years. And he's seen every kind of thing that can happen in the commercial realm with respect to bankruptcy. So with that, I'd like to introduce John. He's going to take it from here. Thank you, John.
Thank you, Henry. Thanks, Henry. I'm John Rezac. I'm in the Creditors' Rights and Bankruptcy practice group here at Taylor English. We had a number of things we're going to talk about today are kind of in response to follow-up questions and discussions that we had after the last session. And one had to do with insolvency. Obviously, when we're talking about bankruptcy, we're talking about issues of insolvency. And we're going to speak a little bit about officer and director obligations when a company is insolvent or is approaching insolvency. It's not so much a litigation practice topic as it is a topic that often leads to litigation. But a first point, and this question was asked after our last session, is what about insolvency? What are the insolvency requirements before a person or a company can file for bankruptcy? And the simple answer is there are none. A solvent company can still file for bankruptcy. Under Chapter 13, which is an individual wage earner case, there are some limitations on the amount of debt that can be brought into the bankruptcy case and still file it in Chapter 13. But while typically our bankruptcy debtors are insolvent or having some payment problems, insolvency is not a requirement. So we'll often see a company file specifically to give themselves some temporary relief from ongoing litigation or from some major event like a foreclosure or something of that nature. And the company files hoping to get some breathing room and have an opportunity to reorganize and essentially work things out with the creditor. But when we're talking about insolvency, there are issues that impact on the obligations of officers and directors. And we start first with the duty of care and loyalty normally of a corporate director. The corporate director has to exercise the duty and care of an ordinarily prudent person under similar circumstances. The courts give a considerable amount of deference to the director's judgment. And as long as they exercise their judgment, they typically are not going to suffer any consequences of their acts. And that's protection they receive under the business judgment rule. In courts looking at whether the business judgment rule is going to apply, will look at the process that the directors have taken to make whatever decision they have. If they've consulted with their experts where necessary, if there was no self-dealing Self-dealing will usually scuttle the business judgment rule quicker than anything else. But it's basically the process. Was it a prudent consideration given before the act was taken or not taken? About 20 years ago, maybe a little longer than that, there emerged a number of court decisions dealing with companies that were insolvent or were approaching insolvency. And these were usually precipitated by complaints by creditors alleging that the directors of the corporation, upon becoming insolvent or approaching insolvency, had an obligation to the creditors as opposed to shareholders. And because they failed in that obligation, the company went under and the creditors suffered. There's a phrase that was coined in the courts is the zone of insolvency, also deepening insolvency, and it refers to those situations where a director should see insolvency on the horizon. A number of the courts the decisions that were published beginning about 25 years ago talked about a shift in the director's obligations. Certainly upon insolvency or upon entering the zone of insolvency, a number of courts held that the director's obligations changed not only in their nature but in who their duties were owed to. Instead of a director being obligated to act for the benefit of the corporation or in the best interest of the corporation for the benefit of its shareholders, there were some decisions that at least suggested that director, upon entering the zone of insolvency, now owed a specific duty to creditors. And Henry?
Is everything you're saying about directors that apply to officers as well?
Yeah, for the most part, yes. I would say with respect to how the courts analyze the execution of the duties, I would say yes. The nature of the duties on their own may vary between directors and officers, but for the most part, these cases deal equally with alleged breaches in duties, fiduciary duties by officers and directors. One of many problems that arose when the court started talking about zone of insolvency was there was no clear definition of the zone of insolvency. There are a number of tests to determine that a company is in fact insolvent, but how bad do things have to get before, as a director, I realize my enterprise is now in the zone of insolvency? Some critics would call liberties were taken by the courts that would have required directors to act really to the specific expressed detriment almost of the corporation in looking out for the interests of the creditors because of this supposed shift in the director or officer's obligations. Another consequence of these rulings was that it made directors unwilling to take certain actions, perhaps to take on certain risks that they might have taken in order to save an enterprise. About 10 years ago, the courts in Delaware issued a number of opinions that, while applicable only to Delaware, were quickly adopted by many other states, and probably since that time have become the law of most of the states in the U.S. It was with a 2007 decision for Jiwala. The court ruled that even in the zone of insolvency, the directors still must discharge their duties in the best interest of the corporation. Where there was a shift, however, was when the director acts on behalf of the corporation for the benefit of the stakeholder of the corporation, the identity of the stakeholder changes upon insolvency. Whereas typically it is the shareholder, once the company is in fact insolvent, the creditors are entitled to payment prior to the shareholders, so they become the beneficiaries of the value of the corporation. The primary difference that makes is actions taken on behalf of an insolvent company that give rise to claims that can be brought by creditors who now have standing as the stakeholders of the enterprise.
Was that a federal district court case, or was it a state court case?
That was from the Delaware Court of Chancery. That particular decision was approved, or at least the decision was adopted by the Superior Court in Delaware. Corporate law being a creature of state law, each state is going to determine what rules apply. But for the most part, folks across country look to Delaware, and most of the courts who have spoken on this have agreed with the Delaware courts. So after about a 25-year cycle, we've kind of come back to the point where the actual duties of a director do not change, certainly within the zone of insolvency, but even upon insolvency, if you boil it down to as long as the director is acting for the benefit of the corporation and exercising his business judgment, he should be safe from liability. The main shift is, and this is only upon actual insolvency, the zone of insolvency concept really has fallen away. But upon insolvency, the beneficiaries of the corporation become the creditors, the stakeholders of the corporation.
Can the filing of bankruptcy give rise to a presumption of actual insolvency, even if it didn't exist in fact?
For certain circumstances, it does. In preference, actually, I believe in preference actions, we spoke about this, basically trustee recovery actions after a bankruptcy case is filed. There is a statutory presumption that within 90 days prior to bankruptcy, the enterprise was insolvent. But that's not necessarily the case in other contexts. So insolvency is still, it's either the balance sheet test or the ability to pay one's debts as those debts become due. It's typically going to be the tests that are used to determine insolvency. You mentioned bankruptcy, though, that this was one of the concerns with when they're. It's still a concern, but when there was confusion about what exactly a director's obligations are now that the company is either circling the drain or getting close to the drain, am I required to put the company into bankruptcy? And is it sufficient that I put the company into bankruptcy and attempt a reorganization? What if I do that and we lose additional value and end up having to do a liquidation? Those things all still are going to be subject to the business judgment rule, but those are exactly the types of issues that were raised by creditors saying you're in the zone of insolvency, you should have immediately run to bankruptcy court, or you should not have gone into bankruptcy court. In some of the European countries, directors have an obligation at a certain point to go and take the business into insolvency proceedings. That's not the case in the U.S. In fact, we don't have a clear-cut rule requirement to go into bankruptcy or not to bankruptcy, provided that the decisions are all made according to the business judgment rule. Any questions about any of that? That's a big overview and a lot to say to really say we've kind of come back to the starting point. I think the decisions of a director for a troubled company are more sensitive, the considerations are more sensitive, and the consequences sometimes are, if not more severe, are more immediate. But essentially, we're still looking at the business judgment rule.
So if a director, let's say, guaranteed a loan that the company had the primary responsibility on, and the director made the decision to make sure the company paid that loan, thus resulting in the director getting off the guarantee, is that something that would be characterized as self-dealing, or is it just looking at the company and whether it was a good idea for it to pay that particular loan versus other creditors?
Henry's question was if a director guarantees a loan and as the company is having trouble, directs the company to pay off that loan to save himself from his personal guarantee. That certainly could be a factor in a court's determining whether there was self-dealing. And so there's no clear-cut rule on it. If there were sufficient other reasons, other benefits to the company by paying off that particular debt, it might not be seen as self-dealing. Certainly it's going to be taken into consideration. Our folks who are more up to speed than I on corporate governance might have some suggestions about what a director does in that situation. Does he have to take himself out of out of the discussion and not vote on that decision? But that in and of itself would not be sufficient self-dealing. The court's going to look to the whole transaction. One of the something that's come up a couple times since our last discussion has to do with the concept of executory contracts and unexpired leases in bankruptcy. An executory contract is essentially a contract where there is sufficient performance still required on both sides of the contract that if either side does not perform, it would constitute a breach. Where it becomes important is when a debtor files for, again, we use the word debtor as the company or the person who files for bankruptcy. When a debtor is a party to a contract and files for bankruptcy, what must the non-filing party do? What are its obligations under the contract? Can it just stop performance altogether? Can it deem the filing of bankruptcy as a breach of the contract or as a termination of the contract? And what about provisions in the contract that address that specifically? The issues are important because we have this concept of property of the estate, and the estate that's formed in bankruptcy. That estate is comprised of all the obligations of the debtor, but also all of the legal and equitable rights of the debtor. And that's where we find non-debtor parties getting into trouble because they take some action after a bankruptcy case is filed that gets them in hot water with the bankruptcy judge. A quick example, this is something we dealt with just this month. Our client had an equipment lease on a truck. The lessee filed for bankruptcy, and the question was, we had repossessed the truck prior to bankruptcy. The question was, can we go and dispose of the truck? Do we have to go and ask bankruptcy court permission? The debtor himself did not even schedule the truck in his bankruptcy filing. So by all appearances, as far as the debtor was concerned, the truck wasn't his anymore. He had no further interest in it. The bankruptcy court sees things differently. So if the debtor had any rights whatsoever under that lease, then the automatic stay that we discussed last time would be enough to prevent our client from going and selling off the truck and applying the balance to the unpaid lease. In this case, we went to court with a motion. We did not get much pushback from the debtor or from the trustee. In fact, they agreed that it should not be considered part of the bankruptcy estate, and we got an order that made it clear, made it comfortable for our client to then go and exercise its rights without threat of being held in contempt in the bankruptcy court. Could have had another situation. The debtor could. The reason why that was most likely, why the order that we obtained was really just a belt and suspenders measure was notices of termination of the lease had gone out before the bankruptcy case was filed. The truck had been repossessed before the case had been filed, and sufficient time had passed such that there was little question that the debtor still had any rights. This was no longer an executory contract where there was performance to be had on both sides. It would be a different situation if the debtor was, if notice of termination had not gone out. If the debtor still retained a right to pay any arrearage and go forward with the lease, then we would have had an executory contract. In bankruptcy, executory contracts are treated as the obligations under an executory contract are treated as effective and ongoing. So if the other party to a contract that I'm involved in files for bankruptcy, I cannot just terminate services. And often that puts an entity in an uncomfortable position. I may still need to send folks out to perform services. I may need to provide goods under my contract, and I can't refuse to do that solely because of the filing of the bankruptcy case.
Is that true even if there's a provision in your contract that specifically says that filing a bankruptcy by the party that ends up being the debtor is material default, obviates all obligations under the contract?
Correct. It may still be an event of default, but the so-called, they're referred to as ipso facto clauses that say upon your bankruptcy, I can do X, Y, and Z, and those are not enforceable in bankruptcy. So if in our truck situation, the debtor still has the truck, and there's a provision in there that says this lease is automatically terminated if you file bankruptcy. If he files bankruptcy, that changes nothing. That provision is ineffective. Those provisions may be effective as regards third parties, however. So if your filing is an event of default, and Mickey has guaranteed the obligations under the contract, I can then call on Mickey to perform because your filing is an event of default. But I cannot enforce that provision against you in your bankruptcy case.
Can I make a demand for adequate assurance of performance?
You can, and what you're getting at is so we still have a contract when the other party files for bankruptcy. So what happens? Am I just hung out there to dry and I have to keep providing value while I'm not getting anything from this bankrupt entity? Typically we're going to have a gap period from the time the bankruptcy case is filed until something material happens with respect to that contract. In Chapter 7s are liquidations. That gap period is usually limited to 60 days. In other chapters, there is no limitation. But typically what we're looking to happen is for the debtor or bankruptcy trustee to either assume the contract and basically reaffirm all the obligations, or to reject the contract. Assuming the contract is exactly what it sounds like. The trustee or usually the debtor in possession in the Chapter 11 case is making a business judgment that this contract is still beneficial, and any burdens of the contract don't outweigh that benefit, and so it is going to assume the contract. In order to do that, it's got to do two things. One is it's got to cure any payment defaults. at the time of assumption. And two, it's got to provide assurance of adequate assurance of future performance. It's different from the concept of adequate protection. I'll touch on that a bit, but it's similar. So that may be showing financial statements, showing ability to pay, showing performance with other similar vendors, depending on the case. But it's got to make you as a non-debtor party to the contract whole in terms of payment, and it's got to give you reasonable assurance that it can perform going forward. The bankruptcy court will determine whether sufficient assurance has been given, and assumption of a contract, of an executory contract, can only be done after notice to all parties in interest in the bankruptcy case and a hearing. So you would have an opportunity to go into court and argue that this enterprise, you cannot pay me next month. Maybe they can cure my default now, but they can't pay me next month or the month after. We're just wasting my time. The other option, the alternative to assumption, is a rejection of the contract. And in that event, a debtor in possession or a trustee has made a determination that the contract is excessively burdensome on the bankruptcy estate. And rejection essentially constitutes a breach under the contract. It's not a termination of the contract, it is a breach. So the non-bankrupt party would have breach of contract damages that then would be asserted by way of a proof of claim in the bankruptcy case.
So you were saying that in Chapter 11 there's no specific time period in which this assumption or rejection has to take place?
There's no set time period. It will happen typically upon two events. The debtor, either because of some pressure by the non-debtor party or just on its own, will file a motion for approval of assumption or rejection of contracts. And often in bigger Chapter 11 cases, there will be a number of contracts listed, and you're either on Schedule A or Schedule B. So you're going to be assumed, and here are all the contracts we're going to assume. Here are all the cure amounts. We owe this guy $10, and this guy $1 million, this guy $5. And we're asking the bankruptcy court to assume the assumption, or assume the contract, approve the assumption of the contract, and to approve these cure amounts. And if the bankruptcy court does, I pay out those cure amounts, and I've got valid enforceable contracts, both ways. And that's another opportunity where you might go into bankruptcy court and say, Rezac says he owes me $5, he actually owes me 10, and we fight those things out. And then there would also be a list of rejected contracts. The other way that assumption and rejection happens, typically in a Chapter 11, is through confirmation of the plan of reorganization. Now, from the start of a Chapter 11 case, the plan of reorganization does not have to even be filed for about half a year. So there's a lot of things going on in the bankruptcy case before you even typically see the debtor's plan of reorganization. So there is quite a gap built in there. But the plan of reorganization will address all nature of issues, one of them being what will happen with all of the executory contracts. Often there will be a blanket provision in there that says any contract not assumed by confirmation of the plan will be addressed later, or will be automatically deemed rejected, or some other provision addressing those. Because there's so much time that just is maybe not built into the process, but is allowable in the process, you will often find a party, the non-debtor party to a contract, going into bankruptcy court and trying to force the debtor's hand with a motion asking for an order, forcing the debtor to make a decision. The bankruptcy courts won't always agree with that. The bankruptcy courts may say this debtor's got enough going on. It's showing its ability to reorganize generally, or at least its ability to get through the process. I'm not going to interfere more than I have to. You just live with the consequences. We'll get around to you when we do. Other times, the court will take into consideration the competing equities and competing interests, and will give what it deems a reasonable amount of time for the debtor entity to make up its mind.
Does the court have the discretion to shorten that 6-month period for the filing of a proposed Chapter 11 plan?
No, I don't believe so. Not 100% sure, but obviously that 6-month period applies in all Chapter 11s, not just with respect to, this is nothing specific to executory contracts and all. I'm going to have to check on that for you, but I do know that time period can be expanded. And usually the courts are fairly willing to lengthen it once, perhaps twice. When you get beyond that, the court wants some real solid reason, particularly if other parties in interest are objecting to the debtors kicking the can down the road. But in the case of an executory contract, what the interested party would more likely do, rather than trying to shorten that exclusivity period when only the debtor can file a plan, would be while we're waiting around for the plan to get filed, force the debtor to make up its mind and assume my contract or reject it. Let my people go.
So let me give you an example that I actually faced a number of years ago. So let's keep it simple. And there's a future debtor that contracted to build 2 playgrounds for 2 different schools, all within the summer time frame before the kids come back to school. And let's say that future debtor is performing on one and submits an application for payment where he's going to get paid a significant amount of money, and also that each contract, let's say, has $50,000 worth of profit in it. So it's a really good contract for the debtor, where they're not going to have to expend a lot of money, but they get a lot of profit. But it files for bankruptcy protection right at the time the money would be coming due from the owner. But in the other project that has to get done within a very limited time period, they have to go out. The only way to get it done within the time period is to have somebody else come in and charge twice as much to get it done, so that indeed, if they were able to set off against the debtor, they wouldn't owe any money, because they're essentially paying for 3 playgrounds in order to get 2. What ability does that owner have, the non-debtor, to say, well, I'm going to set off all the extra amount I have to pay for the second playground against what I owe you on the first one?
So that owner is party to both contracts?
Yeah, both contracts,
okay.
Yeah.
You're bringing up the issue of set-off and recoupment. And just to back off from your question first, both have to deal with offsetting mutual debts and basically netting out how much I owe you and how much you owe me. There are differences between the two. Generally with recoupment, we've got to be looking at one at the same contract or the same transaction. I think in the scenario that you've given, probably would have an argument to make that we are talking about recoupment. The way the bankruptcy court, the general rule is that strict set-off of a debt. You owe me on this contract, and I owe you on this contract. You file for bankruptcy, and you want me to pay you. I want to set it off against this obligation. I typically am going to have to ask the bankruptcy court for relief from the automatic stay to make that decision, even though we're talking about no dollars changing hands. $10. I want to wipe the two out. For reasons I probably don't have time to go into now. I don't know that I could go into now. Set-off and recoupment are generally treated different in that respect. Recoupment, courts are split, but some bankruptcy courts will allow recoupment to be had without seeking relief from the automatic stay. So if we've got the same transaction and there are obligations I owe to you and obligations you owe to me, I can, and you're in bankruptcy wanting me to pay the whole thing, I can pay the whole thing minus what you owe me. I can take advantage of that recoupment without worrying about you running to the bankruptcy court and seeking an order of sanctions against me for violating the automatic stay.
Now, what if because of the time it takes to assume and reject contracts and all that, in my scenario, the owner says, well, I have to go ahead and get this other playground done, and they pay twice as much for it relative to what the debtor was going to get. Is it there is still a possibility that if the debtor assumes the contracts, that the owner will still have to pay the profit on the second project and all the money due on the first project?
That is, as unfair as that sounds, that's a possibility. And I think what the owner would do is go into court with a motion saying, here's the situation I'm in. I need this one to go forward because of this other contract. If the debtor won't commit to performing this, I've got to get somebody else to do the work. Based on that, I need the court to order the debtor to make up its mind. Bankruptcy judges are fairly willing to listen to reasons why relief needs to be granted on an expedited basis. And we find situations just like that. In your scenario, we're talking about a 3 month during the summer, a 3 month period when everything has to be done. We've got to get into court. We've got to have hearings. I've got to take other bids from contractors, and the actual work has to be done. Bankruptcy judges are typically very sensitive to the business needs and business issues. And I know certainly in our district, any one of them would consider getting a request for a hearing on the calendar, right away. But it's one of the situations before we would like that phone call to come from the client before he calls that second contractor, and says, what do I do here? I've got somebody lined up. He's going to cost me twice as much, but I need to get it done. That would be great to have that discussion at that time, be able to get some direction from the bankruptcy court rather than at the end. If the client went out and got the work done, I would say all is not lost, but there's just some uncertainty about how what the bankruptcy judge is going to do about that. I think there are arguments that we can go into court and say we were forced in this position. Our actions were reasonable for these following reasons, and therefore we think this should be we should be able to exercise in effect recoupment, probably a little more than recoupment, and in that scenario. We would actually have a claim, an additional claim for damages against the bankruptcy estate. Waiting until after the fact, obviously, creates some uncertainty, and that's why those decisions are best made.
And if you're the owner and that trying to justify what you did, do all the other creditors, are they all your adversaries trying to say, oh, no, we need to get all this money from that guy who just triple paid for the playgrounds, so we can get it into the estate and have it distributed to us?
They may be. All the creditors, it's the relationship among all the creditors of a bankruptcy estate. They're, on the one hand, united against the debtor. They want to, get as much value out. but they're in competition with each other to some extent. The bankruptcy code tries to level those various playing fields, but that's why I mentioned assumption of these contracts and the terms of the assumption and so forth. Like so many things, are available only after notice and a hearing in the bankruptcy court. The bankruptcy rules of procedure say who is entitled to notice of different types of motions and different things going on in the bankruptcy court, but for the most part, all parties in interest are going to be entitled to notice of a hearing that may result in value going out or into the bankruptcy estate, and that's the creditor's opportunity to go in and say, sorry to hear about Henry and his 2 playgrounds, but here's why you should deny his motion. He's got the deal he's got, and it's hurting the rest of us, the rest of the creditors.
What's the most aggressive action you would take for a commercial landlord? Commercial landlord, the tenant
on behalf
yeah.
of the commercial landlord. In addition to, you were talking about assumption, assumption or rejection of the contracts.
You don't want to wait till that happens.
Right. Whether commercial or non-commercial, there's always seeking relief from the automatic stay. And again, we talked about the automatic stay stops actions against the debtor, the company or the person filing bankruptcy. It also stops actions against property belonging to or even in the possession and control of the debtor. So if we've got a commercial tenant or we've got a consumer tenant in a property and they file for bankruptcy, we can't evict him, but we can go into bankruptcy court and say, here are the reasons why, Judge, you should not let the bankruptcy code protect this person, give us relief from the automatic stay, and let us exercise our state law rights. As you probably imagine, in consumer settings, the courts are sensitive to consumer protection concerns, and kicking somebody out of their apartment is going to have special considerations. Doesn't mean they can stay there forever, but in most instances, commercial and consumer, the bankruptcy court is at least going to consider giving the debtor some opportunity to enjoy the benefits that are intended by the bankruptcy code.
As a practical matter, if you file a motion for relief from the stay on behalf of a commercial landlord, you're not going to get a hearing on that much sooner than they'd have to accept or reject.
Well, the motion for relief from stay here in the Northern District, I believe it's 14 days. Without asking for any special treatment, you can be as close as 14 days to your hearing. And when assuming you're successful at the hearing and you get an order lifting the automatic stay, there is a provision in the Federal Rules of Bankruptcy Procedure that stay the effect of that order for 14 days, but if you can provide compelling reason to do so, the bankruptcy court will waive that as well. So you could have, in 2 weeks, you conceivably, without asking for any special permission, you could have an order granting, an effective order granting relief from the automatic stay to allow you to go forward. If there are emergency circumstances, doesn't have to be emergency. If there's some urgency, you can plead your case to the judge. You can ask to get in front of the judge on an emergency basis. I mean, I've had judges. We've had foreclosures that were scheduled, here in Georgia, the first Tuesday of every month between 10 o'clock and 4 o'clock on the courthouse steps of the county where the property is. We have a bunch of lawyers talking to themselves, reading out the foreclosure scripts, power under sale foreclosure scripts. It's not unusual at all for a borrower to file for bankruptcy Tuesday morning. We've had circumstances where we've been able to say this is more than just, maybe it's not their first filing, maybe there's something fundamentally wrong with their filing where they shouldn't even be able to get in the door on bankruptcy. Might be a prior order prohibiting them from filing a bankruptcy case or something like that. Under those circumstances, we've been able to get in front of a judge that day and get an order from the judge on the docket in time for, Mark Glenn or someone, in Cherokee County, waiting to cry out his foreclosure before 4:00 p.m. So the bankruptcy judges want you to have a good reason. But if you have a good reason, they'll typically listen to a request for expedited treatment. Might not give you what you want. You might be getting to know faster than you would otherwise.
Switching from aggressive to the wise thing to do, is the wise thing to do just try to work with a trustee and reach an agreement on administrative rent?
It depends on the chapter of the case. In a Chapter 7 case, you could probably get the trustee's attention pretty quickly because if there's any reason to hold on to the case, the trustee, there are assets to be distributed. The trustee knows that his or her compensation is going to come just from the money. The money in the estate, so they've got an interest in not allowing excessive burn. So if a commercial landlord were to approach a Chapter 7 trustee and say, "You just got to sign this case. Let me tell you what the circumstances are. We'd like to we'd like to take it back and get your cooperation." You frequently can get a consent judgment from the trustee. And in a Chapter 7 case, it's the trustee's decision. So that could be presented to the judge, and again, you're talking about a couple days, perhaps, if you get their attention. In other circumstances, Frank asked, does it just make sense to be patient, play along with the game, and have an administrative claim, or work with the trustee and have an administrative claim? What he's talking about is the rent that accrues on a lease from the time of the bankruptcy until you either kick the debtor out or the automatic stay is lifted. That rent is treated as it can be treated as an administrative expense of the bankruptcy estate. And what administrative expense means is that it has priority over other obligations, in particular unsecured claims. So if I've got a couple months of rent as the landlord, and the bankruptcy court agrees that it should be treated as an administrative expense, before money goes out the door to creditors, I'm getting paid usually at the same time as the trustee and the trustee's attorney and accountant and so forth. There are requirements, and these are the things, Frank, I think you'd be talking about with the trustee is in order for that rent to be deemed an administrative expense, it has to be deemed to be the actual and necessary expenses of preserving the estate. So if you've got a 10,000 square foot warehouse and the only asset of the estate inside that warehouse is a desk and a couple of chairs, your administrative expense is probably going to be reduced down to the size of renting a cubicle at the self-storage place. But and you drew the line kind of between being aggressive and being cooperative. However, it's characterized, I think what you're suggesting of a commercial landlord, or really any creditors, being diligent and seeing what action can be taken instead of just wait and see, makes a lot of sense. And it's going to save, often it's going to save quite a bit of money.
Under that scenario, is it a good idea to come consult with you or the other bankruptcy attorneys?
Absolutely. That's a good question. We get a lot of questions like this, just, and it's these 2-second questions in the hallway often, but, often longer than that. But, the idea is before a client, makes a significant decision or takes significant steps. We had a discussion about executory contracts in the context of an insurance contract. And the question was, we've got an insurance contract that is paid up until the 1st of next month, we'll say. A significant commercial insurance policy. The company does not have the money to pay the premium right now. Will filing bankruptcy before the 1st of the month keep its insurance in place? And the answer, as so many are, it depends. The bankruptcy code, because that would arguably be an executory contract, the bankruptcy code protects it from termination. So the event of bankruptcy can't be the reason why the carrier goes and terminates coverage. However, the filing of the bankruptcy and the automatic stay will not stop the natural termination of lapsing of the coverage by its own terms. So, if the policy, and where this gets kind of tricky is, if the policy requires the carrier to give a specific notice and then some passage of time after that notice, well, during that time, a bankruptcy is going to, cut things off, and the coverage is going to stay in place until the bankruptcy judge says otherwise or something happens to the case. But if it's just a matter of, if I don't pay by the 1st, I've got no more coverage, I can file bankruptcy before then. It's not going to keep it's not going to keep me covered. Getting to that answer took a lot of discussion with the client and looking at the policy that was in place, and it sometimes frustrating that it's not a quick out of the holster answer, but we're just kind of touching on the surface of these things. Back to your question, we'd love to help out with those questions, and there's often a lot to pick out and consider. Anybody? You good?
Cover the topic you intended to cover?
I did.
Well, again, thanks to John Rezac for providing us a and that is it for Litigation Fundamentals with Henry Quillian at Taylor English.